Hey, everybody. Well, we are back with Patrick MacQueen, real estate attorney extraordinaire. Patrick, thank you so much for joining me.
Thank you for having me.
So today we're going to talk about something that we get a lot of comments on in social media and a lot of questions. And that is, tell us the ins and outs of purchasing a home with somebody that you're not married to. And by this, I don't necessarily mean a family member. So we do see a lot where we have somebody that's going to occupy the home, and then maybe they have a parent or a grandparent or somebody that co-signs for them. I'm not talking about that, although that could be a conversation. What I'm really talking about is somebody purchasing a home with a friend or maybe a boyfriend or a girlfriend or a significant other, but they're not married or community law doesn't prevail in their situation. Can we dive into that today?
Let's go. Yeah.
So going on there. All right. So I just threw up all over you with that comment and that thought, but let's go. Tell me from an attorney standpoint, what your thoughts are of that scenario and why.
Yeah. So, very often we see boyfriend, girlfriend, fiancés, boyfriend, girlfriend, buddies, who want to invest in a piece of real estate. Basically a non-married couple or non-married people joining together to jointly own real estate. Happens all the time.
All the time.
And depending on the circumstances, it could be a good thing. Maybe it helps for probate issues, right? If somebody passes away, the other person gets it, if that's what you wanted to do. It could help potentially for taxes. It could help, mitigate some of the expenses of home or investment ownership. And so there's a lot of kind of fun things about joint ownership, right? We can start our real estate empire this way, right? But there's also a quite a lot of risk. Oftentimes we see people aren't titling, getting the correct title to the real estate themselves, not understanding what happens if and when one of them passes away, not documenting correctly the who's paying for what and who did what for the property, and not documenting what they truly want to have happen if they break up. And hopefully that doesn't happen, but it often does. And people then will come to me, or they'll go to the Google and say, well, what are my options? And my statement is, you don't really have that many options. You can settle, which is a sort of a mutual agreement to get along and sell the house, or somebody lives there and somebody pays or whatever. Or you can do what's called a legal partition, right? So let's say that Kelly, you and I are investors and we co-own an investment property together. And for whatever reason, we went on the deed as joint tenants with the right of survivorship, right? And so let's say that we're no longer interested in investing with each other. What we can do is ask the court to partition, basically split the property, right? And so because we can't directly split it in half, like you could perhaps with raw land, perhaps with farmland, we have to do what's called a legal partition, which is a court-ordered sale. And there's really there's really nothing else we can do under the laws of most states, right? Particularly here in Arizona, I know that with great familiarity, but yeah, there's not a lot of options. And so we could have previously given ourselves quite a lot of options or more options, or had some form of agreement as to what happens if one of us wants to sell and the other one doesn't. But now we really got one option. Either we get along, or the legal option is to partition. And again, because the court can't partition means cut in half.
Right.
Because we can't really cut in half the type of property that people have these days. Partition actually means court-ordered sale, court-supervised sale. Not a lot of fun. A lot of money going out of our pockets as well.
Yeah. Let's walk through the journey. You said that if that is the scenario, so somebody's buying with a friend, and let's first go through the home loan process. Let's assume that they're using a home loan. So they're going to execute the purchase contract with both parties' names on it. They're very likely both going to be on the deed of trust or the security instrument, which gives the lien for the lender. And that's where we're going to kind of label what you just mentioned, joint titles or joint title with right of survivorship or community property, like it's referenced there. Let's kind of dig into what that means. But you're also indicating that there should be maybe another document that's created. Does that get recorded through the county recorder's office with the security instrument, such as the deed or the warranty deed, really? But let's walk through who holds the document, who creates the document, what does the document say? Is it enforceable?
Yeah. So who holds the document? Well, first question was, do we record this document? You can really call it you can call it a joint tenancy agreement, or you can call it a tenants in common agreement, or you can call it an agreement for the disposition of real estate, or whatever it is. And as long as you're describing the parties and describing the land or the property, describing the circumstances behind the purchase and the rationale for doing certain things, describing who pays for what, and that type of stuff, you can call it literally anything you want, and it really doesn't matter. And so the people who keep that document are the parties to that document themselves, whether they're the investors, whether they're the buddies, whether it's boyfriend, girlfriend, whatever it is, they themselves keep the document. Some people I've seen can record what's called a memorandum of that document so that it gets triggered at some point, so that the title company sees, oh, okay, well, we need to figure out who gets what under this document. And so what we don't necessarily want to do is record the actual document, because usually the actual document has business terms in it. We don't personal terms, those types of things. So we record a memorandum of that document. And then all we see is, oh, there's a document floating out there between these parties. Okay, title company has to kind of investigate that a little bit further, just to see if that changes any, disbursements under the sale docs or anything like that. So first question was, do we record this? No, usually you shouldn't. Just like we don't record promissory notes. We don't need to have that recorded. We've got a reference to that document by virtue of our deed of trust or mortgage documents. Your second question was, who keeps it? Well, the party should keep it. The attorney should keep a copy of it. Who drafts it? I've seen Google and AI drafting these. So, and you can tell. I've experimented with that myself just to see what, just because I'm interested in seeing what the AI could produce, and it doesn't get you what you need. It doesn't get you to where you need to be. It might get you a good start. But far too many times I see people pulling those from Google or Rocket Lawyer or whatever the other stuff is. And I think those are good starts, but you really do get what you pay for. And so, if you're going to do it that way, if you're going to download a document, I would consider having a real estate attorney review that document to confirm that all of the terms that are state specific, all of the business terms are in that document. So if you don't want to go through the process of having an attorney do the work, I don't blame you, right? Have the attorney actually just review what you've done, review your handiwork to sort of confirm that it's sufficient. I think that's a great idea. So who drafts these? Attorneys do. Google does. The parties do. Exactly. So we see a lot of interesting stuff when it comes to these types of handwritten agreements or. Yeah. But anyway, yeah. So hopefully that answered all your questions.
Well, I think one thing that's really important, and I see this often, whether this actually comes up even with married people that are going through the divorce process, and that is, I'm just going to claim my interest on the property over to Patrick, and we've agreed on a settlement, and whatever that settlement is, you execute it, and great. Here's what people have to understand. If there is a home loan against that property, that quitclaiming your interest, if you will, away from the property does not release you from the home loan. This is the big thing. It's not like you can just call your lender and say, hey, I got a divorce. The court said it was okay. Here's the divorce decree. I'm quitclaiming my interest. The lender doesn't care until that house is sold or that loan is refinanced into the party that may be retaining the home. You're still on that home loan. And now you get into a divorce decree, let's say, or even with your agreement for somebody that wasn't married. And I guess with the court order of sale in your situation, it's probably a little bit different, but in a lot of these situations, somebody wants to retain the home. That's where this gets complicated, and maybe they're not in a position to refinance because either they can't qualify or they're very low interest rate. They don't want to pay current market interest rates. It can be a variety of reasons, but I just really want to get it out there that make sure you're talking to a real estate attorney or your divorce attorney. You're a professional that can give you true insight into what quitclaiming your interest on a property means if there is a home loan that you are on. That is, without a doubt, probably the most important thing that I can share today because I see it all the time. And Patrick, I've seen crazy stories where people have been divorced for 10 years. And then the person that held the mortgage went into foreclosure, filed bankruptcy. It carries over with that person that was still on the home loan, even though in their minds they think they're divorced, they quitclaimed up, they think they can move on. But until that mortgage, that home loan is refinanced, it can just be out there.
Yeah, no, and you make a really good distinction here. Deeds are different than deeds of trust. Yes. A deed is the document that evidences the type of title you hold, right? Your ownership of the property. A deed of trust is the security instrument that your lender has for securing the loan that you owe them on. And so if you're sort of trying to split those two things up, you better make sure you're doing it the right way, because if you've just given up title to your property, but you're still on the hook, that's terrible, because now that person can trash your credit. Now you don't have any say in what happens with the property or necessarily the loan. And so, yeah, it could be, we've seen that one happen all the time where people either make that mistake or get close to making that mistake. And you're right, the lender isn't going to care until their loan is paid off and the person has actually gone and refied it or paid it off. They don't care. They see 2 borrowers, they see 3 borrowers, they see however many borrowers are on that. That's who they have a loan with, and your conveyance via quitclaim deed didn't do anything with respect to your loan.
Yeah, 2 different obligations, right? I mean, I think the home loan is an agreement or a promise to pay. And then, as you mentioned, the deed of trust is what the home lender is using to securitize their lien position on the house. The warranty deed, the actual deed is kind of the third piece of it that says you and I are buying the property together, whoever it is. The other thing that I think is important to note is that from a home lending standpoint, let's say that we are coming into the picture because the spouse that quitclaimed their interest or the person that quitclaimed their interest is going to go buy a new house. It's easier from a lending standpoint if there's a divorce decree that's final and formal, then a lender very often will use that to exclude the debt from the qualifying borrower. But here's where it gets complicated. Even if we could exclude the debt using the divorce decree, if the person that's retaining the home loan doesn't pay on time, the person's credit that is trying to qualify for the new house, that quitclaimed their interest, their credit is being trashed, because from a credit standpoint, it's still on there. And again, just like all these little nuances that come into it. So I know this conversation started with buying a house with a friend or somebody that is non-married, but I'll tell you, there's so many different scenarios, and it's not black and white, and it's not like one size fits all. So I really recommend that whatever you're going through, just or maybe thinking about doing, consult an experienced home lender, but also consult a real estate attorney or a divorce attorney if that's where you're at, so you truly understand the impact. And then I'd like to have the synergy between the lending company and the attorney, because sometimes there's things that are, need to be said or acknowledged or what's going on that can be helpful to the course of action.
Yeah, no, I totally agree. And, I have some other ideas as well. Even if you're not faced with, divorce or some sort of separation or breakup or whatever, you still need to, account for who does what, account for who paid what, account for the improvements that so-and-so did, but you didn't agree to, account for who's making the payment to the HOA. there's all sorts of this stuff that has to go into something like this. And so a lot of people don't even, they just kind of commingle their money. They get themselves into trouble where I want the shower to be remodeled, but you don't. I'm going to go and do it. And now I expect, because there's, $30,000 more in equity in the property, I just did it because I got the shower remodeled. I get all the equity. No. Well, what happens there? I don't know. We're going to have to figure that one out, and somebody's going to have to come in and praise to see if that work really did contribute to an additional 30% in equity. So there's all sorts of messy stuff. And so a little bit of prevention at the beginning and coming up with one of these documents that says who's doing what, here's how we're accounting for it, here's how we're going to have title, here's what we do if we have a dispute. It does go a long way.
And you mentioned it earlier, but I think it's worth revisiting. And that is, what if one of the parties passes away? What happens to their interest in the property, especially in a situation where they're not married? Especially what if they have previous families? I see a lot of folks that are choosing not to maybe get married, and maybe this is, they'd have grown children and grandchildren and families, and their thought is that when they pass, their portion of the ownership would go to their families. But this is something that needs to be documented somehow, some way. So the memorandum could work in that situation as well.
Absolutely. And so if you have some wishes that you need documented, that this is one way to do it. But here's the deal. If you go into a co-ownership of property with somebody as a joint tenant with right of survivorship, those are the key terms in the deed. If you go in there with that and you pass away, the other joint owner automatically gets everything, all of your that entire interest in the property now. And so if that's not what you wanted, you need to change that. You need to correct that. You need to be tenants in common. You need to have some other title designation to address that, because that can create a lot of problems, as you mentioned, because your entire interest in that property may be going to the other co-owner as opposed to the way in which you wanted it to go, which may have been to your kids. And so, yeah, that can be, that's potentially huge.
What's the difference between joint tenants with right of survivorship and community property with right of survivorship? Just, since I have you, it's free legal advice. Tell us, what is the difference? Because those are the ones I see used most common.
Yeah. So there's actually a couple of designations of community property. Community property with right of survivorship means that you are a married couple here in the state of Arizona. And with the right of survivorship means it goes to the survivor of the two of you, right? Joint tenant means you're not married. Joint tenant with the right of survivorship means you're not married, but your interest goes to that survivor. There's also this designation that some married couples here in Arizona take. It's community property. There is no right of survivorship on that. In that situation, that's a kind of a blended family situation where you want your interest to be able to not go to the surviving spouse. It goes to the perhaps your kids or somebody else. So couple of ways to take property there's about 5 or 6 ways to take property in Arizona. But as to what we're talking about, there's 2 community property designations. Community property designations only apply to married couples. One applies usually in a situation where there isn't the blended family type of situation. One applies when you want your designated interest to go to someone other than your surviving spouse. And so there's that kind of wrinkle to it. And then again, on the joint tenant with the right of survivorship, that means the couple was not married or the people were not married. But the survivor of the people who own it gets to keep the property, the entire amount of property. So in some situations, let's say that going back to the hypothetical where you and I co-own an apartment complex and we didn't want our interest to go to each other. If one of us passed away, we would probably want to do some sort of business interest or something like that. But besides the point, we would probably want to do tenants in common, because then my interest goes to my kids, my family, your interest goes to your kids, your family, as opposed to it going to me or you. So it's so important to take title in the correct manner. And this just issue, co-ownership, when we're dealing with non-married couples, just highlights that so very much.
So let's kind of talk about at what point that comes into the conversation if you are purchasing a home. So let's say that 2 people not married, they execute a purchase contract, they're purchasing a dwelling. escrow, title are opened, and it's not the lender. We're not giving any advice or any information with regard to how somebody could hold title. Generally, that's going to come from the title or escrow company. And so in that case, you're given a document, the buyers are given a document, they have to kind of choose. I think that if there's any complexity at all, or any question, talk to your tax advisor, and it's worth a consultation with the real estate attorney, especially if you have other wishes with the house not conveying to the other party, because most often we see some type of with right or survivorship type of deed preference. And, I always wonder just do they really know? Because I think that sometimes it seems like just a check the box type of thing, because there's so much that goes on when you're purchasing a property that I would just encourage you, if there's anything unique about your scenario or your wishes, if one of you pass away, it's fixable, and it's fixable at that point before you close escrow with just a little bit of advice from a tax attorney or a tax advisor and a real estate attorney. Do you have any other thoughts on that?
No, you're exactly right. So when most people are discussing how they, want to run the show once they jointly own this piece of property, the discussion should be happening or should be clarified and memorialized in writing during the escrow period. That's the most optimal, the ideal time to get this done is during that period, so that once we close, then it's official, we own it. It's a little more difficult to get somebody to change the deed structure, the structure for which they own, how they're going to either take title or own the property, who's paying for what. It's a little more difficult once, life starts getting in the way. And so it's usually, you can do it. You can change your deed after close of escrow as long as everybody agrees. You can set one of these sort of joint tenant agreements up, or tenancy in common agreements up after you close. That's okay, as long as everybody agrees. And so, and as long as everybody's alive to do it. And so, yeah, to me, the most optimal time would be is during escrow while we're still, fresh on the idea and we're getting along.
Yeah. All right, Patrick, I threw a zinger at you, but once again, you came through. So thank you so much for giving us your thoughts on what it means to have joint home ownership with a non-spouse and just things that people need to consider. Thank you so much for your time.